Okay, so jumping back in. So when I say unintentional torts, I mean you didn't have the intent to do the wrongful act that you did, but you still caused somebody harm. What we call that under the law is negligence. You've probably heard that term before, but it basically, it's the unintentional part of liability, okay? Negligence. It is failing to exercise the standard of care that a reasonable person, highlight that. That's, if you can't think of an answer on a test, it's probably reasonable person, okay? Because it's going to be our standard from here on out. Failing to exercise the standard of care that a reasonable person would exercise in similar circumstances. Reasonable person in similar circumstances. Did you do what a reasonable person would have done in those similar circumstances? If you didn't, you might be liable for a tort. If you did, you might get off. All right? So when we get into the hot coffee documentary, and there's 4 different parts of the hot coffee documentary, more of which we'll talk about in class, or I'll post another video about. But the whole premise is never that McDonald's was intentionally, putting their hot coffee out there to burn people, but were they negligent when they served coffee as hot as they did that caused harm to people? So it's not, were they intentionally doing it, it's, were they not acting like a reasonable person or a reasonable business would have in those similar circumstances? So were they negligent? All right? So to prove that somebody was negligent, it requires 4 elements. And you need to know these 4 elements. Number 1, the tortfeasor. When I say that, I mean the wrongdoer. Okay? The wrongdoer owed the plaintiff a duty of care. Did they owe that person something? And we'll go through some examples. So they owed the plaintiff a duty of care. Number 2, which the tortfeasor, or the wrongdoer, breached. So they owed a duty of care. The tortfeasor breached. Number 3, actually causing the plaintiff. Number 4, a legally recognizable injury. So that makes a complete sentence. So the tortfeasor owed the plaintiff a duty of care, which the tortfeasor breached, actually causing the plaintiff a legally recognizable injury. So say, for example, doctors. When we talk about doctors, obviously we hear about medical malpractice suits all the time. That is not that they did anything intentionally. It's that they were negligent. So number 1, did that doctor owe the plaintiff a duty of care? Well, if it's a patient and they're operating on them, yes, they owed them a duty of care. Did they breach that duty of care? That's really where the trials come in. That's where the proof comes in. Did they do what another doctor would have done in similar circumstances? Number 3, did it actually cause the plaintiff's harm? And a lot of times where we see this come into question and really get into the proof and have trials over is like in car wrecks. If I allege that the car wreck caused my back injury, but my medical records show that I've had back problems since I was 10, that might be a hard thing for the plaintiff to prove. And you have to prove all 4. And number 4, you have to prove the injury. You have to have suffered some type of injury or harm. So again, all 4 of those have to be proved for that person to be negligent. Okay? And if they are, you can ask for the damages, just as if it was an intentional tort. Maybe not punitive, although if you have some doctor or you have a wrongdoer that always has a pattern of this type of negligent behavior, punitive damages might be appropriate. Okay, so that's intentional versus negligence. And I think when you watch the hot coffee documentary, having a better understanding of what negligence is, you'll think about it. Okay, did McDonald's owe a duty of care? Well, those are their clients and their customers that are coming to them. Did they breach it? Was their coffee too hot? What were other companies doing in those similar circumstances? Did it cause the plaintiff that harm? Those are all the questions that got answered by the jury when they awarded Stella Lee back a lot of damages. Okay. A couple more things. We'll go quickly on these. Duty of landowners. All right, so as a landowner, of course, I'm never intentionally trying to hurt somebody or cause harm to somebody when they come onto my property. But in order to not be negligent when people come onto my property, either my home or my business, what's my duty? So, duty of landowners. Landowners are expected to exercise reasonable care. Again, when in doubt, pick the answer that has the word reasonable in it. Exercise reasonable care to protect from harm those persons coming onto their property. This is especially true for business invitees. All right, so landowners are expected to exercise reasonable care to protect people coming onto their property, especially true for business invitees. As a homeowner, I have homeowner's insurance, and if somebody gets hurt on my property, I'm going to hope that my insurance covers it and proves that I was acting reasonably. But for business invitees, when you talk about that, think about when you walk into Walmart. Well, not right now because we're all wearing masks and whatnot. But when you walk into Walmart, you see wet floor signs. Well, that's because they're trying to warn business invitees about a slippery spot so that if somebody slips and falls, they can prove that they were acting reasonably by putting that sign out. Now, keep in mind though, some dangers are going to be so obvious that a warning is not necessary. You know, if there's a shelf that sticks out, do you have to put a big yellow sign, flashing sign that says you may run into this? Probably not. Some dangers are going to be so obvious that you don't have to provide a warning. What you're warning against are hidden dangers. A wet floor, probably going to be a hidden danger, and you're going to need to warn against that in order to avoid that liability. Okay. Kind of going back to when I was using my doctor examples, when I talk about duty of professionals, whether you're doctor, lawyer, CPA, whatever you are, engineer, whatever, that individual is going to be held to the standard of care of a reasonable person. Here's the kicker though, with the same or similar expertise or skill. All right, so duty of professionals. The individual is going to be held to the standard of care of a reasonable person, but with the same or similar expertise or skill. So when we have a trial that was this doctor negligent, the standard is not going to be what would Whitney Jensen have done in that situation because I wouldn't have known what to do. It's going to be what would another doctor with that similar training have done in those similar circumstances. So we're comparing apples to apples, not apples to oranges, okay? Engineers get compared to engineers, doctors to doctors, lawyers to lawyers, when we're talking about professional type negligence. Okay, defenses to negligence. You don't have to just sit by and say, okay, I guess I messed up there. No, there's some defenses that defendants can assert if somebody claims they've been negligent. Number one is the assumption of the risk. Assumption of risk. This is where a plaintiff voluntarily enters into a risky situation knowing the risk involved. You assumed the risk. When you did that, you can't say I was now negligent. You see, I get fired up about torts. A plaintiff voluntarily enters a risky situation knowing the risk involved. You went skydiving. You probably signed your life away on the waiver. But if something goes wrong, there's probably going to be some instances where you could say, well, that shouldn't have gone wrong. You were negligent. But for the most part, you entered into that risky situation knowing the risk of jumping out of a plane with a parachute tied to you. And it's probably going to be argued pretty heavily that you assumed any risk that could have been associated with skydiving. Okay? Number two, this comes up a lot with, well, maybe not a lot, but I can see it, with certain tort type actions. Superseding cause. Superseding cause. This is an unforeseeable intervening event that may break the connection between a wrongful act and the injury. Let me say that one more time. Superseding cause. An unforeseeable intervening event may break the connection between the act and the injury. I don't know why I said this probably comes up a lot because the example I'm about to give you is really extreme. But say you've rear-ended somebody on the interstate. You're sitting there and you're waiting for police, wreckers, everything to get there. And then semi comes barreling along and takes everybody out and kills them. I got morbid real quickly. Okay, what the plaintiff, probably the person who's going to sue, is going to be the one that got rear-ended. Their estate, their family is going to sue. They're going to sue this person right here for first they're going to sue this person for the rear end. But what this person is going to argue, the one who rear-ended them initially, is that the death was not caused by them rear-ending that person. The death was caused by a superseding cause, by that semi flying through and taking them all out. Okay, they're going to say that their wrongful act of rear-ending that person, even though they didn't mean to, that act and the injury that resulted from it, that injury was not caused by that rear-ending. The injury, the death, was caused by the semi coming out of nowhere, barreling through and taking them all out. Okay, so that's a superseding event that breaks that connection between the act and the injury itself. Sorry, that got real dark. Okay, number 3, contributory negligence. This is only a defense that's going to be used in a few states. All right, this is where a plaintiff is barred, B-A-R-R-E-D, barred from recovering any damages at all if the harm they suffered is partly their own fault. Again, this is only the case in a few states, and it is not the case in Kentucky. But contributory negligence means if the plaintiff who's suing the defendant contributed at all to their injuries, they can't recover anything from the defendant. Number 4, this is what Kentucky follows, comparative negligence. A plaintiff's recovery is going to be reduced in proportion to their own fault. Sure, you may have run the red light, but I was also going 85 in a 60. There's some comparative fault there. Or a plaintiff sues 2 defendants and then tries to allocate the fault between the 2 of them. Maybe it's not all your fault, but it's a little bit your fault and a little bit your fault, and we're going to let the jury decide who's at fault how much. Comparative negligence. We just compare the negligence of each of you and reduce your damages in compared to your amount of the fault. This is used in the majority of states, used here in Kentucky. So those are defenses. You get sued for negligence. You don't just roll over and concede. Those are some defenses that your attorney would put up on your behalf. Couple more things. Strict liability. You've probably heard this before, but strict liability is liability regardless of fault. Regardless of whether you were at fault or not. In certain situations, strict liability is going to be imposed on you, meaning you are liable whether you were using the utmost reasonable care or not. If something went wrong, you are liable, regardless of whether you were at fault. This is going to be in situations using explosives, dangerous animals. If I'm housing a tiger back here in my yard, it doesn't matter if I put up a 15-foot fence. If he gets out and causes harm to somebody, I'm going to be strictly liable for that. So in very rare but outrageous situations is where somebody's going to be strictly liable for whatever harm is caused. All right, last but not least, products liability. So obviously you've heard of that. You see class actions all the time. You see recalls for products. Well, that's because they're about to be or they have been liable for something that went wrong with their product. So product liability is the liability of manufacturers, sellers, and lessors, L-E-S-S-O-R-S, of goods for injuries or damage caused by those goods to consumers, users, bystanders, to anybody. Not anybody, but, a defined group. Remember, you have to have a stake in the action to be able to sue. So products liability, the liability of manufacturers, sellers, and lessors of goods that cause injury. So whenever you file a products liability claim, there's really 3 different theories that you can claim that company is liable for a defective product. Number 1 is negligence, meaning they didn't do anything intentional, but they didn't live up to the standard of care of a reasonable person, a reasonable manufacturer. So when I'm talking about negligence, I'm talking about a negligent design of the product. You were negligent in selecting what materials you were going to use to put the product together. probably to save a buck, which has now bit you in the butt because you're getting sued. But it's not that you were intentionally doing anything. It's that you didn't exercise the appropriate standard of care when you were creating the project, designing it, promoting it, whatever. But you can be sued for negligence. Number 2, fraudulent misrepresentation. We've already talked about that once, but that's a basis for bringing a product's liability claim is, hey, manufacturer, hey, seller, you misrepresented to everyone purchasing and using this product that it would do X, and it does Y. It's not as good as you promoted it to be. Obviously, we all use puffery when we're talking about how great our products are, but intentionally misrepresenting material things that we relied on when we bought it, and it caused us injury. So you got to pay up now. And the last one, strict liability. Again, there's going to be some instances where manufacturers, sellers, they're going to be strictly liable for the product that they have put into commerce and we've purchased. And because of that, regardless of whether they're at fault, they're going to be liable for the injury that was caused to us. So one thing I want to circle back to and make sure you remember and keep in mind in all of this, whether it's suing somebody because they did something intentionally or suing somebody because they didn't do it intentionally, but they just didn't exercise reasonable care, you have to be injured before you can sue. Remember, you have to have all 4 elements. For negligence, you've got to have an injury, but for an intentional tort, you have to have an injury. Okay, so there has to be an act, and there has to be an act, whether intentional or unintentional, but it has to cause that injury for you to be able to haul that person into court. You have to have sustained some injury or damages before you can sue that person. So, there's an overview of chapter 4. All right, torts. Again, I'll get with you in class and through Blackboard about the hot coffee assignment, how this all ties together when we talk about tort reform, when we talk about torts in general. And hot coffee will really tie it together and show you some real world application of this crazy word known as a tort. So, all right, stay tuned.